Hello everybody and welcome to another episode of Bots and Billables. And let's talk about what happened in legal tech and legal AI this week. A lot. Again, the world is spinning very fast. This week we start with 2 topics and 1 publication, and we try to keep it crisp but entertaining and informing. Number 1, legal update this week. There is a big win for Anthropic by winning US District Court decision of Judge Alsop, ruling that using copyright protected books in the US to train models is considered fair use under US copyright law. This is super relevant. This is very relevant because the whole claim had been considered a claim that could become precedent for others, and there are several other claims waiting to be resolved. Background to this, in I think mid last year, 3 authors have brought a claim against Anthropic, the company behind the models like Claude, claiming that the Anthropic models have been trained on copyright protected books and that the model needed to be taken down or essentially stop being used. And this is a damage claim. The issue was obvious. You use books that are published by other people, copyright protected by other people, and also you train your models based on books that are already published in an illicit way, talking about Library Genesis, like the LibGen website, and Pirate Bay data. All the books, all the publications available there have been probably used by Anthropic to train their models. And the big question was, how do we deal with this? And the news is obviously shocking. Judge Alsop rules that this is a case of fair use. He rules that using the data to train your model is actually what people would consider a creative act, and say that this is not a large-scale theft as claimed by the authors, but in fact a creative and almost necessary way that doing this to train the models was actually quote-unquote quintessentially transformative. Enough to create its own IP, enough to actually create a case under fair use policy. This means that probably other models will fall suit, and this is actually something to be further used. The judge compares the training of the model to the reading of a human person as an aspiring writer, quote-unquote aspiring writer in the judgment. So there's a lot to be said about this. Like, people who are hoping that models that are trained on foreign copyrighted data would get in trouble. With this decision, we are getting more to the conceptual comparison of the model training with human training, and we're applying the same creative requirements of somebody using third-party material to that of a human being. Wow. But also wow, because there are more cases where the lawmaker has not envisaged a bot or a technology consuming the content. And there are more situations and instances where the situation is now not even more unclear, but almost allowed. I'm talking about the ability to, for example, read copyright protected material to not train models, but read copyright protected material to create new copyright protected material. We are talking about all the cases where you have copyright protection, where you need like substantial creative effort to actually create new IP, where we are now having the door opened to more technology-infused and technology-assisted work. So this is nothing but a surprise, but also something that has been expected by people watching the cases. There has been a second, almost contradicting opinion about this in the Meta case. Meta wins another lawsuit here. However, the situation is a little bit different because the judge does in fact conclude that using GPT on this data has a market impacting consequence, and that the way that Meta trained their Llama models on copyright material was potentially infringing. So we have 2 almost contradicting judgments this week. with the US District Attorney from San Francisco, Judge Alsop, making headlines and opening the door wide on this. So we will stay tuned, we will watch this. This will change the world. I think it's safe to say that. Then, second headline this week, big one, Clio acquires VLEX. You all probably know Clio. If you don't, Clio is probably the market leader for practice and matter management software for small and medium-sized law firms. Comes out of Canada, founded by Jack Newton, and has made headlines because it raised the, I think, biggest round of venture capital in the history of legal tech back in 2023, raising 900 million and valuing the company, I think, at 3 billion. Now, Clio acquires VLEX in a not just cash deal, so this is cash and stock, and people are surprised. This is one of the biggest transactions ever. This is a big sign for legal tech. This is a big sign for the valuation paid. And there are many things to say about that deal. So, first of all, Clio needs to compete in a market that is increasingly driven by the publishers. Clio competes with Thomson Reuters, Clio competes with other practice management software, so they want to probably have content and they want to increase tech. VLEX is a content company. They have both the tech and agentic and AI frameworks to actually read content, but they also have the case collections. Essentially, there's Thomson Reuters, Lexis, and VLEX, and now with VLEX, they have not just a US-focused case collection, but a global legal collection that allows people to do research on proved and validated data. This is relevant for everybody in the market that needs legal content to do their work. So, Clio gets this case collection to leverage it in their practice management software. Why is this so relevant? Because, first of all, Clio is a matter management company that sells software. They now have content. That means that Clio is essentially able to combine the legal work with the, let's say, legal project management of work. Classic legal work like drafting, working with your client, preparing the drafts, the briefs, and working on your matters was usually separate from doing research. Like you had two separate work streams. Like in the past, this would have been literally physical separations because you would get up and go to the library for research and then sit down at your desk and do your legal work. And this has become increasingly close. So of course you now have different browser windows open. You would do your research in one and then you would do the drafting and the legal work in the other one. And now this merges. So Thomson Reuters, with the acquisition of CoCounsel, has shown that drafting and legal work can be one, and you bring research into your work streams and closer to what you're doing, you merge it. You also make it better because research becomes easier. You, instead of actually conducting a search, you can use the information from your legal work to enhance your research, and the other way around, bring, for example, legal sources faster into your documents. If you have a Microsoft Word plugin and you have your legal sources available through your plugin, all you have to do is, while you write your brief, is to type in, please give me decisions that support this case, or decisions and arguments that I have missed here. So you can really work with your research while you do your legal work. And Thomson Reuters and CoCounsel have proven that this is the future of research, and we're going there. Many publishers have followed that. Lexis with the acquisition of Henchman, Lexis with building their own solution, other publishers buying their own companies. So now Clio buys a company that has the content, but also the agentic and bot availabilities to do this, and brings it into their matter management closer to their clients. Jack Newton and Clio say they want to do this because of going upmarket. Many people have said this is a natural move for Clio because Clio is served by the medium-sized companies. Now they want to go upmarket, and this becomes a new competitor selling into bigger law firms. There have been people that said they're skeptical of that because that move means also different software, different enterprise setup. This is not the same. However, there have also been people that are saying, now we have another company that has the full service package, and whether or not they go upstream or not, this is like serious competition to everybody else who either offers practice management or who offers research, because Clio probably was tired to lose customers that can now offer research and legal work with another practice management system. So whether or not this is really an upmarket move or whether this is just market expansion, market defense, we don't know. It's interesting to see that Clio has the size now, after the fundraise from a couple of years ago, that They may eye an IPO. And this is maybe things you would want to do if you want to have the perfect IPO story, because you need AI to your story, and now they have it in two ways. The content, which is considered especially hard to get, the IP, and the tech to actually work with the content. So this is super relevant and a decision that many people have been talking about a lot. This is what it means. If you are a law firm, you can see the market of vendors that offer content and the tech consolidating and people paying attention here. If you are in the venture business and you think about valuations and you think about the whole M&A market in legal tech, what I think is most interesting about that transaction is that you have a company that used to be a startup and knows the market super well and is not a FOMO-driven big corporate that pays $1 billion and presumably a 12 to 13x valuation on a company to basically plan the path for the future. That's not very, let's say, hypey. That is somebody who knows what they're doing. And that shows even more that maybe the change is real. Like maybe this is really happening now, and very, very close to the market company that would probably even, and believed for years into the build versus buy more, actually does a move like that. This is incredibly relevant. So interesting news this week, and we'll see how this continues. This gets us to our topic number 3. Publication of the week is an article by the Legal Tech Hub, actually 2. Legal Technology Hub, if you don't know the platform, I recommend you to follow them because the platform is quite relevant. It is a basically analyst focusing on the legal area, and they have issued a new quadrant. So similar to Gardner and Forrester analysts that publish this on the tech world at large, the LTA issues those for legal specific. And they have published the quadrant for law firm focused contract review. Why is that relevant? Because their quadrant actually now combines for the first time really incumbents and new entrants into the market in one quadrant, and shows companies that are mostly machine learning driven to companies that are mostly LLM driven on one chart. So if you don't know it yet, have a look. The quadrant, as usual, has the 4 fields. You have the contenders, companies that are relatively leading in their feature offering but are newer to the market. Then you have the companies that have been in the market longer but have the feature lead. And then you have the 2 groups that are less strong on the features and are either new to the market, meaning that they're emerging, or they have been in the market but maybe have lost the edge on the features, which means that they are becoming the specialists because they have increasingly focused on very narrow use cases. So that's the map we're talking about. And in this map, you suddenly have a number of names that you have seen in the news. Harvey is there with their tool Vault. Legora is there with their grid review. There's a company called Hebia that has been in the news because of their very Excel-like extraction grid that is quite powerful. Beam and AI is there exactly in the middle. And now you have a number of other companies that you know well because they've been around for ages. Kira, Litera, you have Luminance in there, TR, and you have other companies. And the interesting thing is that they're now combined in one scatter plot. So if you look at this, quite interesting because Legal Technology Hub makes an effort to show the differences and map them. It's interesting that they publish this on the market because this shows how the new generation of tools are being adopted and being used together with the old stuff. If you talk to people about the relevance of contract extraction software, I think everybody agrees that people would say the prices are dropping, things become more easy, and the new generation will probably make it easier for more people to use the tech. We haven't seen how the market really plays out, but Legal Tech Hub publishing this gives an interesting orientation about how things play. And another publication coming out the same day from LTH is the Race in the Middle. This is one just because I found it extremely interesting, being a workflow company that then offered an AI suite to the market to see how Legal Technology Hub sees the market from this perspective. So they have this interesting juxtaposition of movements where companies that have started with Gen AI capabilities added more enterprise and automation focused capabilities later, versus companies that started with the enterprise and workflow capabilities, then basically build the AI tools. So you have two groups of companies now converging in the middle, and it's quite interesting to see how that plays out. This visual, by the way, is not the first time that I see it. There was a newsletter by Peter Duffy in his Titans newsletter that I recommend you actually also subscribe to, who had a very similar picture back when we released Beeman, I think in March, where he said there are companies like Legora and Harvey that started as an AI assistant and then added the bulk doc review, then added the Word plugin, and now realizing that they need to go into vertical use cases and become more like practice group oriented, individual use case and problem oriented, now go to basically build workflow capabilities in there for people to actually custom build more solutions. They're adding workflow. While a company like Brighter, in this case it was about our press release, had the workflow, built the bulk doc review, built the Bird plugin, and now builds the AI assistant. So companies are meeting in the middle. This picture of Peter Duffy, I found it very entertaining at the time. It's also a little bit gossipy. Now, ironically, Legal Technology Hub has a very similar view on the market where this converges, where people who offer workflow now build an AI assistant, and the other way around, the AI assistants add more capabilities. Every company is defined by their origin. If you start with workflows, you have a more workflow-driven view to the world. You're probably a more technical-focused company. If you're a Gen AI company, everything's probably a little more focused about how to make it quick and fast and user-friendly, and you're focusing on the Gen AI bit, and everything through the AI through a prompt, which is why, ironically, what Harvey and Legora announced this week is workflows is a version of prompt chaining. Like you chain different prompt steps one behind each other, and you basically start to bring in the determinism of the conditionality to basically structure the prompting. So it's technically not the same as what workflow companies did by giving you app building capabilities, front ends, databases, and more power. It's still the workflow capabilities of the Gen AI companies is still in the realms of making prompting more user-friendly. But it's not hard to see that there's convergence happening, and it's quite interesting in the market how things move. So these publications have been publications that I like to read, and I can recommend them. I hope you have a great rest of the week. Enjoy the weekend. And I think I see you next week in another episode of Bots and Billables. Take care until then. Bye-bye.